for central counterparties, otherwise known as CCPs, and that's how I'll refer to them for the rest of this committee. These regulations make necessary technical and consequential legislative changes and provide legal protection for certain contractual arrangements to ensure that the regime operates as intended. Resolution is the framework for managing the failure of certain financial institutions. Now, within this framework, the Bank of England is the UK's resolution authority and leads on resolution processes once instigated. The UK's current resolution regime for banks and building societies was introduced in 2009. This was partially extended to CCPs in 2014. A new bespoke and expanded regime for CCPs was created this year through Schedule 11 to the Financial Services and Markets Act 2023, recently passed in this House. CCPs are firms that provide clearing services for large volumes of financial trading activity. They sit between buyers and sellers, and they guarantee the terms of a trade. They are systematically important pieces of market infrastructure, because without them, the financial system cannot function effectively. The failure of a CCP and the resulting loss of clearing services that they provide could lead to serious consequences for financial markets, financial stability and public funds. The UK's expanded resolution regime will enhance the Bank of England's resolution powers and ensure the UK is aligned with international standards on CCP resolution. To fully implement the expanded CCP resolution regime, the government must lay a number of statutory instruments. Two of these are being debated today. Now, the modified application of corporate law and consequential amendments regulations make necessary changes to certain existing legislation to ensure that the expanded CCP resolution regime can function as intended. These modifications have two principal impacts. First, they mirror changes to company law that apply within the bank resolution regime. Secondly, they make wider consequential amendments to broadly ensure that certain consequences for CCPs in the resolution process are consistent across the existing and expanded regime. This maintains continuity with the existing resolution regime for CCPs. Now, turning to the second set of regulations, Schedule 11 gives the Bank of England the power to make partial property transfer and write-down instruments when resolving a CCP. The partial property transfers and safeguarding of protected arrangements regulations ensure that these instruments do not affect protected arrangements that underpin the effective operation of financial markets, including things like set-off and netting arrangements. Now, netting is one of the mechanisms through which a CCP reduces risk in financial markets. Multiple financial obligations are aggregated to calculate a net obligation amount. This means that losses in one position on one trade can be offset with gains in another position in another trade. Given the importance of this function to the operation of clearing services, these safeguarding regulations ensure that set-off and netting arrangements are protected when the Bank of England uses its property transfer powers. This is particularly relevant for partial property transfers, where the Bank of England can transfer all or some of the rights and liabilities of a CCP. The Bank of England also has the power to write down liabilities, meaning that they can cancel, modify or change a security or the form of an unsecured liability owed to the CCP. These safeguarding regulations also restrict the Bank of England in making write-down instruments in cases where there are protected arrangements, such as those related to netting. Now, in doing so, these regulations ensure usual market practice continues and disruption to financial markets is minimised when the Bank of England takes action, whilst also providing certainty for market participants as to how they'll be treated during resolution proceedings. Together, these regulations ensure that a resolution can be conducted as effectively as possible whilst reducing the impact on normal market functions. Now I come to the third and final set of regulations. These regulations, which are called the Payment and Electronic Money Institutions Special Administration Regime, otherwise catchily known as PSAR, I won't try and pronounce that. These regulations will expand the application of the existing insolvency arrangements for electronic money and payment institutions so that they apply to firms in Northern Ireland and Scottish Limited Liability Partnership, otherwise known as LLPs, as they already do in England and Wales, as well as for companies in Scotland. Now, the payments and e-money sectors have expanded rapidly over the last decade. As the sector has grown, the government has become concerned that the application of standard insolvency procedures to the failure of these firms was leading to negative outcomes for customers. Now, in order to manage these risks, in 2021, the government legislated for a special administration regime to provide for the prompt return of client assets should such a firm fail. This regime was delivered through the Payment and Electronic Money Institution Insolvency Regulations 2021 and the accompanying rules. These regulations established the special administration regime in England, Wales, and for companies in Scotland. Now, this regime created special administration objectives, which an administrator will have to follow when conducting an administration of a payment or electronic money institution. These objectives are to ensure the return of customer funds as soon as practicable, ensure timely engagement with payment systems operators, the payment systems regulator and the Treasury, the FCA, the Bank of England, and to either rescue the institution as a going concern or wind it up. Now, one further statutory instrument is required to ensure the regime can effectively apply to Scottish limited liability partnerships and to firms in Northern Ireland. The distinct nature of both Scottish and Northern Irish insolvency law required this SI to be prepared to a different timetable than the original regulations. So this is effectively a tidying up measure in that regard, in order to ensure that the regime can operate effectively under both legal frameworks. In conclusion, Mr. Paisley, by expanding the application of these regulations to the relevant firms in Northern Ireland and Scottish LLPs, these regulations will ensure we have robust arrangements to manage the potential insolvency of payments and electronic money firms throughout the United Kingdom.
Thank you, Minister. And you so move all three instruments?
I do. I so move.
Minister, would you like to respond to the points that have been raised?
I would. Thank you, Chair. I would like to thank all honourable members for their consideration of these regulations. To address the honourable members' opposite's points, in relation to accountability and proportionality, which is the summary of his points, it's important for the committee to recognise that these regulations do two principal things in conceptual terms. First of all, it is a tidying up exercise to bring together what was an intention passed as part of the FSMA Act 2023 under Schedule 11 and to deliver on those, which has got the support. But it is to do that really as a last backstop measure because we hope that these powers will never need to be used. This is done as a means to absolutely make sure, in the event that it was absolutely critically necessary, the Bank of England had the relevant powers that it needed. So that is the purpose of it. In relation to the broader points around accountability, I look forward to working with him in my time in this post to broadly strengthen Parliament's accountability over all regulators as he set out. And in terms of proportionality, it's worth saying that there is a requirement for the Bank of England when these powers would be in place to consult and work with the Treasury in the event, as I say, the rare event where we hope that these powers would be used.